Good morning, everybody, and welcome to Law and Crime. I'm Jesse Weber, joined here by trial attorney Brad Micklin. We're going to break down the biggest live trials and legal stories in the news today. We are going to be live in multiple courtrooms, a lot to discuss, a lot to break down, so let's get started. Now, Brad, glad to have you here. We'll listen to what is considered the aggravating circumstances. The state is presenting these to try to say, hey, jury, if someone deserves the death penalty, it's definitely this guy. What are your thoughts on it? How they doing?
I agree. I think that in South Carolina, the death penalty is if there's multiple victims or if there's victims under 11. Here we have both. I think the only mitigating factor that he has is the claim that he couldn't appreciate his conduct, but that's not going to fly because they didn't find him insane. So
yeah, you took the words right out of my mouth, and I wanted to ask you that. If the jury, who had the option to just find him guilty but mentally ill, and they chose not to do that, they said, we find you guilty across the board. That's a signal to everybody else that they don't believe this mental health problem. How much can the defense during the penalty phase still put on arguments that he has a mental disease?
they have to. I mean, it's not going to be successful, but they have nothing else.
But legally they can do that.
Sure. There's nothing that bars them because that's what they introduced. Just because the jury didn't find it doesn't mean they still can't argue it. And they have a duty to argue the best that they can, and I think that's the only thing they can. We have 5 dead children here.
Yeah, I imagine also they're going to talk more about, his upbringing and what his life was like and what all the factors that led into this decision. Now, I'm getting word that we can go live right now into Jones. I said to you at the beginning, we're waiting any second, and we're going to go live right now, new witness on the stand. Well, this is absolutely heart-wrenching testimony, and Brad, I see what the prosecution's doing here. It's really painting a picture of what the world is like without these children. What's interesting is this wouldn't have been allowed in at a trial, would it have?
No, never. First, it's really not significant or relevant to whether or not he killed them. But more importantly, it's so prejudicial. A jury sees these sweet young children, they're going to want to find and punish somebody. So we have to keep things like this out, at least to the penalty phase.
But it's allowed here for the penalty phase.
Because it goes to the type of victim that he killed and whether or not there's a mitigating or aggravating factor to it.
Looks like aggravating to me, if you ask me. You're listening to the elementary school teacher of Eli, who was 7 years old when he was killed. This is just really, really emotional stuff. And joining me again is, of course, Brad Micklin, but also is trial attorney Richard St. Paul. I'm glad to have you both here. Richard, I want to start with you.
Sure.
Oh boy, what is the defense going to do here? I mean, you see the defendant crying, showing some emotion, a rare thing that we see him during the course of this case. Does the defense even cross-examine this witness?
No, it'd be hard to do. I mean, they want to bring on their own witnesses to talk about some mitigating circumstances. You've heard some of the mitigating circumstances before, which basically dealt with the fact that the defense was trying to bring up that he was suffering from mental illness. So you want to bring up some mitigating factors that are going to help him get the life imprisonment versus the death penalty. And you want to humanize him also on a defense. So you may want to bring on some character witnesses to say, look, as they've done before, he's really not a bad guy. We've never seen any violence from him. This is just out of character for him. So that's what the defense objective is going to be, is to humanize him and bring up some mitigating circumstances.
Brad, would that work? I mean, we believe that they are going to call family members of Jones to the stand and maybe talk about his difficult life and his upbringing, his mother institutionalized. What effect does that really have on a jury, especially here where they convicted him of killing his 5 children?
I think it's going to have little effect. I mean, that between the number of victims, the age of the victims, the cruelty with how he committed these acts, and his past history of criminal offenses, I don't think there's anything that's going to mitigate this.
And Richard, real quick, do you think we're going to see a statement from the defendant at any point?
That's a very good question, and I don't think it's going to be helpful for him to speak at all. I think it's going to be, as Brad said, the jury to sympathize with him is going to be very difficult. So.
I agree with you. I think, even seeing him crying, I don't know if that's going to have much of an effect, if at all. Some difficult testimony, even for the witness. Richard, what's your reaction to this?
This is very difficult to hear. I mean, obviously, we heard a little bit about Nathan and him being a student who was looking for love, and this teacher, Mr. Stone, was trying to show him that love. And then we go right into some of the abuse that Mr. Stone noticed on Nathan's body. It's really tough for a jury to hear this type of information and not make a decision that the father, Mr. Jones, deserves a death penalty. It's really hard to hear that type.
Yeah, and Brad, what is the defense going to do? I mean, they cross-examined the other teacher. I'm not sure what the strategy was, saying that he enjoyed being with his father. His father came to open houses. What's the strategy here?
It's hard to tell. I think with the first witness, the defense should have done more to show how good of a father he was, or the lack of information that the first teacher may have had about whether he was good or bad. This teacher's up just to show how bad of a father he was. So I think they really need to rehabilitate this witness to show that maybe he wasn't familiar with what went on, maybe there was misunderstanding.
Yeah, and listen, we're going to have to see what happens in the next hour of testimony, because this is day 2 of the penalty phase. There is a lot at stake here. In fact, it's the defendant's life at stake, and there's a lot to consider for this jury. Okay, welcome back, everybody. Wow, that was emotional. Joining me on set are trial attorneys Brad Micklin and Richard St. Paul. Richard, I'll start with you. No cross-examination there by the defense. I mean, it was just so unbelievably powerful what he just testified to.
Yeah, exactly. You don't want to get further into a witness who's already testified about something so emotional, so you just kind of move on. There's no way to rehabilitate this witness, so you just hope to get another witness where you could talk about positive things, those mitigating factors with the father. But remember, the first witness was the teacher, where they spoke about the father participating in the kid's life. Here, you didn't particularly have anything to talk to Mr. Stone about,
right?
Because there was so much emotional and physical abuse that he testified to.
Brad, what other witnesses do you think the prosecution is going to call, or maybe should call?
Well, I think they're going to call some of the Child Protective Service witnesses, because the information about the history of abuse does need to be introduced to really bring it home for the jury. They also have to, I think, bring some other witnesses about the children, because it's going to leave the jury wondering why, if they talked about these 2 children, for instance, they didn't talk about the other 3. So I think that's a combination they're going to need to meet.
And we're waiting to see what the defense will ultimately do, but I can't help but wonder what happened yesterday, Richard. We see these videos of the kids crying. These videos were taken from the mother's phone. They're videos that were taken about a year before what ultimately happened. And then we also learned more about how the bodies were discovered. What is the prosecution trying to show here?
Well, look, they're showing the aggravating circumstances. First of all, as we saw in the that keeps hopping up on the screen, that he rode around for 9 days with the children's body. That's just a total disregard for them. Not only just killing them, but confessing to killing them, but what is he doing afterwards? He's riding around with them. It's a total disregard, both in life and afterlife. And so those are aggravating circumstances of why the prosecution is trying to prove why he should get the death penalty, because look at this treatment. Not only did he kill his kids, but look what he did afterwards, after he killed them.
Yeah, and Brad, just to reiterate once more, the thing that's unique about this is that the jury doesn't believe mental illness. I mean, you tell me, their determination to find him guilty across the board when they could have found him guilty but mentally ill, does that signify to you that this jury is saying, we don't believe he was mentally ill. We don't believe he had a traumatic brain injury or schizophrenia. This was a conscious decision on his part. So defense, if you're going to decide to bring some experts on or some witnesses to talk about his mental health, we're not buying it. What do you think?
I agree. I think having the option that they do in South Carolina, that not every state does, I think is a clear signal from the jury that they're not going to look at mental illness at any issue. And if you look at what he did before, during, and after, there's no question that he knew what he did was wrong.
Yeah, but it was definitely an interesting part of the trial. And now we're getting more, again, as you both said, we're in the penalty phase, and we're trying to understand exactly where the defense will go. But let's just go back to yesterday when we heard another important witness, Janet Richard, an elementary school assistant principal. We're seeing a lot of these school teachers, administrators, principals discussing what the life of these kids was like and what their perspective was about what was going on in these kids' lives. Let's see a little bit more from testimony from yesterday. Again, the idea is, what will the defense do? Richard, even if they call these witnesses to say he had I'm talking about the defendant, had a traumatic childhood. His mother was institutionalized. How much does a jury say, well, maybe I can't sentence him to death. Maybe that's not, he's a human being. It's not, while what he did was wrong and against the law, we don't think he deserves that punishment.
Look, it's certainly reasonable to think the jury may consider some of that mental illness in the death penalty versus life imprisonment phase, where they didn't consider it for his guilt. So certainly they may want to say, you know what, we heard the psychiatrist say that he knew what he was doing. We looked at his actions, before and after. We believe that he knew what he was doing. But maybe some of this mental illness, his upbringing, maybe that did affect him and why he did it. And therefore, we shouldn't vote for the death penalty. So they may consider it now, more so now than they did before.
But Brad, even in the most egregious cases, it's still difficult for a jury of human beings to recommend death of another human being if you want to classify Timothy Jones Jr. as a human being.
I don't think it's going to be that difficult in this case. If there were one victim or two where they were older, it'd be different. You have 5 children. And again, he stuffed them in bags. He drove around. He knew exactly what he did was wrong. He didn't report them missing. I don't think there's a question that they're going to sentence the man to death.
Well, let's see. We have more that we're going to analyze on our end and what they're going to analyze. This is Joy Lorick, the victim's former babysitter from yesterday. Well, she is familiar because she actually testified during the trial phase, and the emotional impact of these kids' deaths clearly has reverberated for anybody who knew them. We're seeing that from yesterday and today, and really that's what the prosecution's doing here, Richard. But you tell me, a jury, they have to weigh these aggravating, these mitigating circumstances. How do they weigh that? There's no mathematical formula to do it. How do they weigh it?
Well, look, as you mentioned before, Jesse, jury, they're human beings. So they have emotions involved in their decision making. Now, the judge gives you instructions to say, here's the facts, apply that facts to the law. But at the same time, it's hard to take that emotion away from people. So the jury will go back with their charge once all the testimony is done, and they will weigh it with their life experience too, in addition to what the judge's instructions were. And again, it's very hard to ignore what has happened here, the facts, 5 children dead. It's very hard as a human being to ignore that.
Brad, is it a good thing or a bad thing that the same jury has to make this determination? On one hand, are they only supposed to consider what they're hearing in the penalty phase, or are they also supposed to consider what they heard during the trial phase? Would it have been more impartial to have a jury come in just for the penalty phase? I'm curious your thoughts.
I think it would be more impartial. I think it's from a defense standpoint, it would be better to have, in this case, an independent jury that didn't have to hear all the horrible testimony. But then again, if it was a different jury, the prosecution would probably bring much of the evidence back. So in the end, in a case like this, I don't think it would matter.
And Richard, do you think at any point the defense is saying, man, we messed up? Because the reason I say that is I look at the witness who was just called this babysitter. She was called as a defense witness. And as we just talked about in break, I still don't understand what the value of her testimony was for the defense. And we could argue that they called other witnesses that really didn't help their case and even hurt their case. Right. Do you think they're going back and saying, well, maybe we shouldn't have called X, Y, and Z. Maybe we had they started off strong with a defense of saying that he had schizophrenia and a brain injury, strong witnesses, and then they concluded their case with a witness who said, in her opinion, that he met the definition of insanity. Do you think they're going back and saying, well, maybe we shouldn't have called these kinds of witnesses?
Well, look, this particular defense where you have 5 children that are murdered is a very, and when you have a father talking about how he strangled, one of the child, it's a very tough defense.
Oh, yeah.
And their largest factor in terms of their defense was the mental illness. And then after that, there really wasn't much of anything else. Now, the father had custody of the children, and this is what the babysitter, as you saw, just testified, and so he essentially hired that particular babysitter and can talk about how the father was around the children, and that would be the hope for the defense, to humanize him and say, look, he was a good father, but for this mental illness, this would have never happened.
Right. And you talk about the biggest travesty of it all is that Department of Social Services had an opportunity to intervene beforehand, Brad, but they didn't. There were 3 instances, 3 cases when they saw the evidence of possible abuse, but there wasn't enough to take the kids away at those times. What do you think of that? What can we learn from it?
I mean, it's a challenging position for any protective services. It's a very significant move they have to take if they're taking children from somebody. They have a great volume of cases. But I think it brings a question to, what was the mother doing all this time? If she had to know the protective service investigations also, and it didn't seem like she acted, so they're less culpable, I think, than she is.
I'm glad you mentioned the mother, because we believe she is going to be one of the witnesses that testifies during this penalty phase. And we all remember her reaction during the trial phase. She just broke down hysterically crying. We may see the same kind of thing once she testifies in the penalty phase. But we have more to cover, and there you go, that was her. That was quite the moment during the trial. In fact, the judge had to excuse the jury, had to stop her testimony because she did have quite the emotional outburst, understandably so. Let's take a quick break. When we come back, more to analyze, more to break down, and a lot to cover here on Law and Crime.